Okay, here we are. Somebody give me a thumbs up that you're seeing a slide that says post-pandemic criminal courts. Thank you so much. Okay. All right. So this is a photo in the background of the Milwaukee County courthouse, and this is one of our research sites, as I'll explain in a minute. So we know that the pandemic has brought about, big sustained changes in how attorneys do their work, some positive and some negative. This quote here comes to us from one of the St. Louis judges that we interviewed. It's just, to me, means that it's going to take a reckoning to understand how courts operate now and how much they have been impacted by the criminal justice system changes, from court closures, suspension of speedy trial rules, and moving everything to a virtual format. It's not like my job at the university where I'm teaching, and for a year I taught online and everything was moved online, and now I'm back in person. It's relatively unchanged. I think we see, and I look forward to hearing from you, kind of the more deeper, more enduring impact that the courts have seen. So the study I'm going to be describing today reports on interviews with prosecutors, defense attorneys, and judges. I'm going to focus on the defense attorney responses. We had 6 private defense attorneys, although some of them were taking cases from the public defender's office, and 17 defense attorneys total. So I should note that the interviews were not evenly split. We talked to more judges in Milwaukee, and we talked to more public defenders in St. Louis. So I will be giving some of the judges' responses too, in that they really highlight those courtroom worker relationships and some of the issues that judges were identifying. So this is research conducted just at the end of the last year. Both of these jurisdictions have some important similarities that we thought would help us kind of draw more broader conclusions. This is part of a larger research study, and I'm excited to say that we have a report coming out next month in September that you could check out, about the larger research study exploring prosecutorial discretion in the plea bargaining process. So this study was funded by the MacArthur Association through the Safety and Justice Challenge Research Consortium, and my co-authors are all listed there. So we, pursued a number of research questions in a number of different ways. We had some administrative data and some surveys that we administered, and then also these interviews with all the different members of the courtroom work group. But a lot of those questions are looking at, how do prosecutors make decisions in cases? How do they make decisions regarding, what to charge, how to negotiate, when to reduce charges, all those types of things. But today we're really focusing on specifically how the ongoing COVID-19 pandemic and subsequent restrictions impacted the plea negotiation process. And so, when I was looking at what is already out there about how attorneys are impacted by COVID, I found less than I was expecting. I have heard complaints from some journal editors saying that they're sick of COVID-related research, but actually I'm finding a lot of that research concerns more policing and corrections. There's less about courts, and as far as I could tell, if somebody knows better, please do tell me, nothing yet about how courtroom work group members' habits and negotiation styles maybe have changed as a result of the pandemic. So I had to go back a little bit into, of course, Eisenstein and Jacob and Eisenstein's work in Contours of Justice and Felony Justice, and those great court ethnography. And I remembered the importance of proximity to work group functioning that was discovered in those studies. So in other words, when attorneys are in they share an offices in the same building, or maybe they like hang out in the coffee room or the scheduling room, or what have you. There's more opportunities for informal interaction, and scholars have found that these types of opportunities lead to better negotiation, maybe faster case resolution. And then similarly, when attorneys are familiar with each other, have worked together for a longer time, it has the same effect. So for our interest today, we're sort of taking that idea and looking at, okay, so what's the role of isolation? How is isolation going to affect negotiation? I found that the National Center for the State Courts, as you probably know, has produced a lot of research, helpful surveys. Arizona, Michigan, and Ohio all surveyed their judges and attorneys. And I was interested to find that there was a lot of support for continuing virtual proceedings beyond the pandemic. And, also research indicates and identifies, obviously, this trial backlog that has accumulated. We'll talk about the implications of that. And then also an important interest in how are, defendants understanding these decisions that they have to make. What is the risk of coercion in this new environment? All right, so our interview questions that focused specifically on sort of pandemic era issues were, how have plea negotiation practices changed since COVID? What challenges have you faced in negotiations or interactions with the courts during the pandemic? As courts are reopening, how's the process going now? What are those challenges? And then, are there any changes that you would want to sustain even after the pandemic? And so these were, conducted in a semi-structured fashion where, the questions weren't always asked in the same order or in precisely the same way. And it also allowed us an opportunity to pick up on, sort of special expertise and experiences that folks had, and, pursue different questions. So I'm hoping that these interviews will provide some additional context to some of the surveys that tend to have more like pre-structured formulaic questions. Here, hopefully we're getting at kind of broader perceptions. So the majority of our interviews were conducted remotely over the phone or on a Zoom call. It was in the middle of pandemic, obviously. They were all audio recorded and stripped of identifiers to maintain confidentiality. And so, you may have heard this quote: the COVID-19 pandemic is not the disruption that courts wanted, but it is the disruption that courts needed. I think it was a Michigan judge that said that first, but it just really resonates. So I think of these findings in terms of, these are the types of disruptions that courts are experiencing, and we're going to explore each of these three types a little bit today. So first, obviously the change in communication styles, a lot more remote negotiation happening, and, those fewer opportunities for, as one prosecutor put it to me, just shooting the shit with the defense attorneys. Virtual proceedings. So defense attorneys that we interviewed did support the continuation of using virtual format in some circumstances. Public defenders a little bit less enthusiastic than private defense attorneys maybe, but we did hear that support in certain contexts. But they also shared concerns over how things were different from one courtroom to the next. Not being able to predict what the judge was going to want. And then also the digital divide and how it's affecting their indigent clients specifically. And then finally, the trial backlog. So how that has increased the workload and, perhaps led to some increased attrition. All right, so starting with our communication work group styles. Just some of the advantages that private defense attorneys and public defenders cited for preferring their stated preferences for preferring remote negotiation is one that now prosecutors respond to their emails. So, we often heard that, oh, some of these older prosecutors, if you didn't track them down in the courtroom or in their office or something, you were never going to get a response. That had become less of a problem over the pandemic. Particularly, I want to say in the latter part of 2020, that these prosecutors were getting a little bit more accustomed to having to communicate over email. Now, I should say, this isn't all about email. I mean, some people said, maybe it could be Zoom, maybe it could be a phone call, but just this lack of in-person negotiation was seen as a positive for some attorneys. And then, one public defender told me that they really prefer email because it provides a record of the negotiation that they can share with their client, just having thing on paper, having that record. More focused negotiation. So communicating through email about, okay, when are we going to talk? And then when you do talk over Zoom or over the phone, you've set aside that time, you're prepared to talk about the case. You're not in a courtroom with all of these other distractions and all of these other, things going on, and maybe other attorneys trying to get your attention too. And so some found that actually they were able to give it more of their attention. And then also that it alleviated pressure on defendants. So, we'll speak about this more in the context of virtual proceedings as well, but that through email, you have more of a protracted negotiation, gives everybody a little bit more time. And so some of our public defenders particularly found that beneficial. They also said that it meant more time for them, more work for them, but that it might have benefited their clients. Now, some participants made comments suggesting that the attorney's age, if they were older, or the number of years on the job, for example, how accustomed were they to negotiation styles pre-pandemic, that those sorts of things could have an impact on what negotiation style they might prefer. But, we saw mixed results for that. When I really went back and looked at the demographic data of our participants, I found that the six attorneys who highlighted the benefits of email, 5 of them did have less than 5 years of experience in their role, and all of them were under the age of 40. On the other hand, among those attorneys who clearly stated a preference for in-person communication, they varied in age and experience levels. Like, I can't really make any generalizations about them. So here's what they had to say. So these are the folks that preferred in-person negotiation. Actually, many of the prosecutors missed in-person interactions too, but this public defender points out that they felt that there was the possibility of increased hostility over email, not understanding, not having that give and take, obviously, like less, empathy. The full quote that I couldn't fit on the slide. Also, they say some of our younger attorneys, especially if they make a pitch by email and they just get a snarky or angry response from a DA, like, well, your client should have thought of that before he did whatever. So not even really engaging with the merits of what the requests are. So that was cited as a disadvantage. Other attorneys just felt that it was less effective. They felt that, they weren't getting the result for their client that they wanted, like this private defense attorney who says, I could make a passionate speech and the person could just be like, yeah, they didn't reply. But if you've gotten a hold of them in the hallway or you pop your head in their office, that has a lot of value. A judge's perspective. So we did hear a lot of interesting comments from our judges. This judge is a former public defender who found that often the parties didn't seem to have spoken before they came to the hearing, and they wanted to stress the importance of the defense and the prosecution getting together to specifically talk about, mitigating circumstances, to give a picture of the defendant. And so this was, kind of a recurring complaint too, that attorneys weren't as well prepared, and that when they did everything over email, it tended to draw out case resolution, that cases were not getting resolved as quickly. So more about that later. But these judges' concern, and I think also probably as an interest in a training program, Milwaukee County developed a pilot project. We don't know yet, what their conclusions are of this program, but I can tell you the impetus behind it. So they are ordering prosecutors and public defenders to be in Zoom conferences prior to the pretrial here at some time prior to the pretrial. So the idea is that they will have exchanged discovery during this Zoom conference, that they'll just be looking at each other face to face, have a meaningful discussion about the case. And then I think there is this training component to it where the supervisors might be in the background and can help kind of mediate some of those conversations. All right, now adjusting to the virtual format. We heard widespread support for continuing to hold things like status conferences and scheduling hearings online. So, a lot of people said, oh, this is so much better. That was a waste of time before. So, even public defenders that were maybe a little more concerned about their indigent clients' ability to access technology, many of them did also say that they felt that the virtual court provided for more efficiency. Some of them said not as disruptive to their clients' lives. Particularly private defense attorneys were also likely to see the advantages for their clients. And then this comment about, virtual court being economical, I think is in recognition of the fact that private defense attorneys don't have to charge as much if they're not traveling as much. If they're charging by the hour, they can spend that time in their office and actually be working on the case rather than be in their car. So I just do want to give the caveat that this support for moving some types of proceedings online definitely didn't carry over to, for example, like virtual trials, even virtual bench trials. We had a public defender talk about what a nightmare it had been to try to hold a virtual bench trial. I guess apparently bench trials weren't in high demand, so I don't think they tried to do that again. But evidentiary hearings, things like that, pretty much uniformly everybody agreed. There was some of the judges and maybe some of the prosecutors were thinking that, well, maybe we can do plea and sentencings online. So there was a little bit of wiggle room in exactly what would continue to be virtual. But other disadvantages that we, most commonly heard just about really moving any hearing to the virtual setting was glitches, obviously. Sometimes even the internet connection. I heard the Wi-Fi at the Milwaukee County Courthouse wasn't even the most reliable. And then this was really a repeated issue that we hadn't anticipated, was this issue of judicial inconsistency. So St. Louis public defenders telling us that, For some of their clients, it worked out really nicely, but for other people, for example, clients that had difficulty with the technology and the judge was just going to order them to appear virtually anyway, or, didn't want them to call from their car, or, these sorts of things where judges' idiosyncratic preferences regarding the virtual appearances, whether defendants had to appear on video or could call in, whether they had to appear at all. One St. Louis judge told us they didn't require defendants to appear for like a status hearing really at all during the pandemic. And then, judges would maybe have in their schedule that it was going to be online and then change to in-person at the last minute, and just created like frustration and confusion for the attorneys and their clients. And then I'm sure you're familiar with this digital divide. And so folks did speak to us about how they felt like there's the potential that this technology is going to exacerbate problems that already existed, that those most vulnerable would continue to struggle, and that now maybe there weren't the resources for them, that judges were maybe not understanding enough about folks' lack of experience using technology. Many of the judges remarked about this lack of decorum in the courtroom. They remarked about other things too, but this was something that almost all of our judges mentioned at some point. I'll just give you a minute to read the quote. I don't see this as being an explicit call out to defense attorneys to correct defendants' misbehavior, but it is, implied that, one joke that a judge told me was even the defense attorneys were not always recognizing the formality of the court either. So it was a little bit of shade to the defense attorneys, but also, judges just expressed the concern that maybe they were losing control over this forum a little bit, that the virtual format didn't have the formality, and also that they weren't getting as good of a sense of the defendant that was standing in front of them. Others feared that defense attorneys and their clients had trouble with breakout rooms, or just in general weren't communicating with each other, similar to the comment about concern that prosecutors and defense attorneys weren't communicating. So there were a number of issues that judges raised. So in St. Louis, one of the reforms that St. Louis County has implemented during the pandemic, they established this tap-in center in collaboration with the library. I think is so cool, where they have like a couple of days a week where individuals can come in and meet with an attorney, apply for a public defender, meet with someone from the bail project who's present, get their case rescheduled, get warrants lifted, and then all, while also accessing the library's free Wi-Fi. The trial backlog. So we heard from public defenders in Milwaukee that, some of their newer attorneys handling misdemeanor cases were handling, 300-400 cases. People talking about having, 10 homicide cases at a time. In St. Louis caseloads, most of the public defenders cited somewhere around 150 to 200 at the most cases. So of course that's, going to be exhausting and difficult to deal with. The causes of this, obviously, we know some of them, but comments from some of the St. Louis public defenders also indicated that during a period at the height of the pandemic, prosecutors may not have been sufficiently motivated to act. So public defenders are frantic trying to help their custodial clients, trying to tell them something about their case, when actually there's just not a lot of movement because they are not really getting responses from the prosecutor's office. They didn't necessarily know whether that was because prosecutors were also having difficulties, technological difficulties, difficulties getting discovery from the police department, what have you. But there was just a lot of frustration very early on in the pandemic that even cases that maybe could have been moving were not moving. We were told that some judges just didn't hold court at all for like a year. The lack of a trial threat. So this increasing, prosecutors' lack of incentive that maybe they don't need to get started investigating that case because they're not worried about it going to trial anytime soon. And then also defense attorneys did acknowledge that there were some advantages to delaying, particularly cases for their out of custody clients. So, as for the advantages of waiting, police officers can retire, witnesses can move away, judges were even saying that sometimes the longer the delay gives them an opportunity to observe the defendant out of custody. And that, if things go well during that period, that they might be likely to reduce the sentence. So, defense realizing this, clients realizing this for all sorts of reasons. The out of custody clients also did not have a lot of incentive to move cases. So here we are with the situation where we are reopening the courtrooms due to social distancing. I know that in Milwaukee, they did it on a staggered basis. They had some courtrooms reopening and not others. I believe they're back up now, but they have these very they told me crippling, I think was one of the quotes, overwhelming, crippling trial backlogs. So we find that these will probably have long-term consequences. So of course, justice being delayed. So thousands of cases that are not going to get through for years, people having to wait for a disposition in their cases. Increased pressure to close cases from the judges. And then also, as with any backlog, a strain on attorney-client relationships. Some defense attorneys describing, how difficult it was to try to explain to their clients that they had a suspension of their speedy trial rights because clients have a lot of institutions that have failed them. And now this is one more institution that is failing them by drawing out their case. And then complicating matters, there were these staffing issues. So in St. Louis, I don't have figures for you on this, but anecdotally, it does appear that almost all of the people that we interviewed at the time of the study in the public defender's office are no longer there. So just seeing a lot of turnover in that office. And then we also heard the same thing in Milwaukee. So this public defender spoke about how it wasn't just public defenders. It was also prosecutors, court reporters, court clerks, court deputies, bailiffs. And, they described interestingly that this isn't, necessarily, it's a confluence of factors. It's the increased workload after having, maybe a little bit better of like a work-life balance during the pandemic, coming back to what was already a big workload before you left that has now doubled. It was that, certainly, but it was also the aging workforce. I heard that, the public defender's office, even in Milwaukee, tended to have more people that were, getting ready to retire. Budgetary cuts, obviously, leading to poor pay. So there was an issue of the Milwaukee defense attorneys having to worry about not meeting their caseload during the pandemic and whether or not that was going to affect whether they got raises in the subsequent fiscal year. Just really sad. So I bring up this issue as an issue of, how is the pandemic going to affect training for new attorneys? How's it going to affect recruiting new attorneys? And then how's it going to affect attrition, retention issues? Now, I want to return to this question, coming to the end here. I want to return to this question of how the pandemic influenced pleas and the plea negotiation process. So, one interesting, thing to contemplate in the literature is, has the pandemic led to more trials? Has it led to coerced environment for pleas? And I think that our findings present as sort of a mixed bag picture here. So I have two columns. In the column more, are we going to see, more trials? This lack of opportunity for in-person negotiation. If we trust what the literature suggests, that maybe more adversarial relationships will come about as a result of this lack of in-person interaction, familiarity, especially with a lot of attorneys leaving and things like that, that could hypothetically lead to more trials. And then also we did definitely hear that non-custodial defendants had become more likely to assert their right to trial. Whether those will actually end up as trials or whether those cases would be dismissed, I don't know. And then on the plea column, definitely we're hearing that trial slots are more precious than ever. And so I can only imagine that there's a reduced incentive to take cases to trial and an incentive to resolve them as quickly as possible. Also, I'd be interested in your feedback on this. I'm just imagining that novice attorneys might be less likely to take cases to trial, particularly those that have been trained during the pandemic, that aren't in courtrooms watching trials, and that probably from their experience of the last 2 years have not taken any cases to trial. So it just goes to show, I think, how research studying this is going to be really important to disaggregate data and understand, all of the nuances and the different variables and separate them out and make them distinct, because surely there will be an impact. We're going to need all different types of data to understand, though, I think, what that impact really is. And then areas for future research. So this question of the plea versus the trial versus dismissal rates is still very volatile and probably jurisdiction specific and an obvious area of interest. But there are also a lot of other directions I can see here that this presentation got me excited to think about different directions, particularly for folks that want to explore how this is related to indigent defense. So, how has the pandemic affected attrition? How are novice public defenders learning on the job in a remote context? What is that training going to look like now? How is that changing? How has the pandemic affected attorney-client relationships? I'm sure there's some literature about that already. How do clients feel about virtual proceedings? So I know, and others have pointed out, that there's a dearth of research about how are defendants experiencing these processes. Unfortunately, our study doesn't shed light on that, and I would love to read a study that did. And then I think, more research on what are the effects of different modes of negotiation. How's that going to affect the courtroom work-group relationship? How's that going to affect case resolutions and outcomes? So I've lost all track of time. I hope I didn't talk too much. Okay, it's 12:30. I think I'm good. But yeah, please do tell me your thoughts now. I'm going to stop sharing, and then, please do also reach out to me over email later if anything should come to your mind later. Oh, good, hands. I'm going to let Andrew moderate this.
Thank you, and I'll try and do it with as light a touch as possible. I think I saw Paul's hand go up first. Can I call on you, Paul, please?
Yeah, sure. And I apologize, I can't turn my video on. I'm driving, but for one, thanks for the presentation. I thought it was really great. I was actually curious to know, for one, if you looked at any data in Wichita, Kansas, or Albuquerque public defense. And the reason being is there's an article that came out recently. I think it was in ProPublica, and I'm not sure if it was sent out on the IDRA publications or not, but it was talking about two different cities, obviously, who didn't really shut down much during the pandemic. They really quickly, within, I think it was like 45 days or something, kind of started trials again. And they found that the violent crime increase that's being seen across the country in many jurisdictions did not actually take place nearly to the level as pretty much almost anywhere else. And obviously, I didn't see the data to be specific, but I guess I'm curious from a standpoint of that. I think the insinuation of the article was that justice delayed sort of results in more crime because people weren't seeing justice happening, and there was actually an implication that some people's violent offenses were actually retaliation because they weren't seeing justice being done in the courts. And from that mindset, I'm just kind of curious: have those lawyers seen differences through the pandemic as opposed to lawyers where the jurisdictions didn't have trials going on for a long period of time, and maybe even some of your jurisdictions opened up sooner, and were there differences in the data from that?
Yeah, that is a super interesting question. I did not see that article, but I'll check it out. I assume a Google search for like ProPublica Albuquerque, pandemic courts might pull it up, and crime. Yeah, I mean, that is how courts have functioned that didn't really close up, maybe in some of these more rural jurisdictions. I certainly do need to acknowledge like the limitation of our study. Thank you. Got the link now. Perfect. It draws conclusions based on two Midwestern urban jurisdictions that proceeded in largely similar ways. So I think that's a really interesting question. The question of like whether suspension of trial would have an effect on violence, that seems a little attenuated to me. I mean, I did hear in Milwaukee, I heard one of the Milwaukee public defenders spoke specifically about how part of the problem with their increased caseload, I think particularly for those more experienced attorneys that were handling more high-level cases, that they were seeing more crime, that their caseloads were higher regardless. Their caseloads were higher because of the increase in gun violence, basically.
Really fascinating hypothesis, certainly. Let's see, Professor Alcon, I see your hand up.
Yes, it took me a minute to get my unmute button, so thank you. And I'm sorry I can't turn on my camera. I'm at Texas A&M, so just a little ways away from SMU. And this is really quite interesting. I very much appreciate the research that you've been doing and the reporting on it. One of the questions that I had relates to what your findings were in terms of the negotiation atmosphere. And one of the things that we know from the negotiation literature is that you do better in a face-to-face negotiation. If you don't want someone to say no, the best way to accomplish that is by being in front of them, right? It's easy to say no over text and over emails. And the literature, I think, is really just not developed yet on how does that remain the same with Zoom as compared to in-person face-to-face. But I think it's a fair bet that Zoom's better than text or email on that front. But it led me to be thinking about, you had said that there was going to be training, particularly in Milwaukee. And one of the other things that we know is that public defenders and defense lawyers have much of no training about negotiation and negotiation skills in the context of plea bargaining. And I'm wondering if you were asking that question of your participants, like had they had training, how much training, how did that impact their thinking about what they were doing in their negotiations?
Okay, first of all, thank you, because you've just made me realize I really need to consult the psychological literature on negotiation styles. And I think that's just such an astute observation that just in general, like how do people respond when they say yes, when they say no? So thank you for that. And then now I've lost track of what your the other question. Oh yes, negotiation. So are they trained? Yeah. So that was definitely one of the things that came out, was that there was a lack of training. There was, I'm really curious how like on the job training worked out during the pandemic. I did have some defense attorneys indicate to me that they felt like the attorneys that were newer that had started during the pandemic were struggling. And one person told me that they just had somebody leave because they just couldn't deal with it. But then across the board, I mean, also from the prosecutors' offices, we heard, kind of, well, we should do more, acknowledging we should do more of that. Yeah.
Great. Well, if I may follow up with an email, and I'll send you some of the articles that I've written that talk about negotiation in the context of plea bargaining that you might find helpful jumping off points. And then if you're not familiar with it, Ron Wright and Jenny Roberts did a really good article a number of years back. And I can send you that link if you need it to, or send you that site if you need it. So I think both of those.
I love Ron Wright.
Okay.
Yeah, terrific. Thank you.
So, yeah. Okay.
Thank you.
Thank you for your research.
Wonderful. Well, I want to keep inviting folks to put up their hands when they have questions. I know folks on this call have done work in this area, and many of you are just experiencing it on the ground. So please do keep the questions coming. You can stick your hand up, or you can write them into chat. Liz, I'm one fascinating thing that I just feel like maybe you're experiencing in real time is I feel like the moment that the pandemic hit, researchers were immediately motivated to sort of track the impact of it. They just wanted to know sort of what the heck was happening. And there's a sense in which your research represents a second generation, maybe, because now the question is, what's the new normal? Are there things, we all know that in the immediate aftermath, the question was, just how damaging is this? How on earth are we going to cope? What even is going on? But it seems to me like as the research has developed, and obviously a lot of people focused on it, but now people are asking the kinds of things that you're asking, which is, what are the lasting effects? And not only how are people adapting to the pandemic, but how are people, I'm not sure what quite the word is, but it's more like, what does the world look like now? Do you think that's right? And do you think that part of the question that we should be asking is how much of can we go back to 2019, and how much is this just a new normal?
Yeah, I love that idea of continuing research, because I mean, people that complain that there's too much COVID research, well, I mean, we have to understand what we're dealing with. I mean, a lot of the conclusions and that were drawn, like, in the courtroom work group studies, and a lot of that stuff has to be revisited now, because of course it's on a jurisdiction by jurisdiction basis. But there I go, I'm back. Yeah, I think that's a really great observation, that and I actually think that the National Center for State Courts has done a great job of that. Certainly there's more that they could do, and there's a lot more that needs to be done. But yeah, I mean, particularly on the courts, on how courts are going to operate now. I just, my experience, I mean, I don't know if we have folks that are practicing on the call, but my experience of going to the courthouse is just, there's nobody there. You're still just walking around in empty hallways, and that certainly has impacted the ability to continue to do this research. So we had, initially hoped to have more, justice involved folks as part of the study too, but recruiting is just incredibly difficult in this environment. So I fear that might be one of the more longer term, more sustained, I mean, I hope not, but it could certainly be that that's a sustained impact of the pandemic, is less access for researchers.
And you may have mentioned it, and I may have just skipped it. Did you do a lot of your interviewing in person or in some other way?
No, very little did we do in person. Yeah, some folks, had availability for us in their chambers, or what have you, but most of it was done over the phone or by Zoom. And so, just like it's easier to say no to people in a text message or an email than in person, this is also affecting our ability to do qualitative research.
Yeah, thank you very much. Do you think that if you were to redo your interviews now, that you would hear people saying new or different things?
Yes, And that would be another limitation of the study. You know, it's just like this race to understand the findings, and to get it out in the world, because, right, I mean, it's changing all the time. We were talking to people late last year. Pretty much a lot of our interviews were before Omicron. So at that time, we had a lot of people saying, oh, we're really looking forward to, you know, having everything be back to normal in January. And then, you know, I think Omicron did change their ability to get back up.
Right. Thank you. Paul, I see your hand back up again.
Yeah, I'm curious also, just from the plea negotiation standpoint, if, as you were talking to public defenders, if you were noticing a difference in trial win rates. You know, right, just as the pandemic was coming was the Black Lives Matter movement, which I think really pushed jurors to open their minds a little bit more. And we have seen incredible amounts of win rates for defense attorneys. And I actually think that that has also helped us in our plea negotiations to some degree, because we've even seen the benches pushing back on prosecutors, saying, you need to start pleading some of these out. We have huge backlogs and you keep taking these loser cases to trial. Did you look at that at all, at win rates at all, and the impacts that might have had on plea negotiations?
No, no, I mean, unfortunately, at the time of our interviews, there were just so few people that could speak about that. I think maybe, you know, you're pointing out a great area of future research, and particularly how that might assist in plea negotiations. That's just fascinating. Mr. Tom Reed.
Yes, I run the public defender's office here in Milwaukee, so I'm very interested in hearing all these this feedback, and I'm glad that many of my colleagues shared some of their concerns, because there are very real concerns. I will comment on the last question, which is, yes, I do think that there has been a change in the number of cases that we're likely to prevail on. And I think some of that is about a change in the sort of way in which jurors think about some of the social issues that I think maybe in before the kind of George Floyd focus on racial disparities and how they impact things and focus on policing. I think a lot of our Milwaukee jurors were much more willing to give the benefit of the doubt to the, to the prosecution. I also think that there is as has been commented in the research, a lot of loss of experience, a lot of, kind of challenges to having cases well prepared. And I think that, the defense attorneys have been a little bit better at taking advantage of that. But the point I want to make that I think is of interest, and I haven't heard it in your comments to date, is I think that the effect of the pandemic and the pandemic backlogs has been to significantly shrink the available bandwidth that people in the criminal justice system, prosecutors, judges, and defense attorneys have to consider questions that are really important to the kinds of changes that we as a society need to make in our criminal justice system, but are hard, they feel almost like luxuries in the face of the imperative to get cases resolved. So that if you want to talk to a judge or prosecutor about why it is that a particular pattern of prosecution or a particular pattern of policing has, deleterious effects in the communities where those things are occurring, and you want to use those kinds of arguments to support your request for some reduced charges or some kind of mitigated sentence or whatever it is that you're asking for, the capacity to have that broader discussion, which I think did exist before the pandemic, that's gone with a lot of the negotiations that take place. People are just too busy. They feel like they don't have time to engage those issues and to think about them, clearly. And efforts that we have underway to try to elevate those discussions, not just in our criminal justice system, but in the community interest that surrounds the criminal justice system, those efforts have been really compromised. You can't have community meetings, public open meetings. You can't have some of those, casual conversations that people who are practitioners need to have with people who are not practitioners, because those settings are gone. The Community Justice Council meetings are virtual. The meetings that might take place in neighborhood settings, those are virtual and they're not the same. So I think what has happened is a reduction in the breadth of considerations that enter into negotiations, to the detriment of the interest that people have in seeing new thinking and new ideas be part of how we address criminal cases. And I don't think that's necessarily a permanent problem, but until we have staff stability and institutional stability and more manageable workloads, I fear that the people in the system who have the most chance to improve our system outcomes have a greatly diminished capacity to think about those things and incorporate them in their decision making, and that's concerning, obviously.
Gosh, thank you so much for that. Yeah, I mean, that's just an insight that I hadn't heard. I think I hear you saying two things. Once that it's more difficult to have those kind of big picture conversations with prosecutors and negotiations, but then also that it's more difficult to have those conversations with the community and be in conversation with the larger community. Is that right?
Yes, and I think it's not just conversations. I think that effective conversations require the capacity to do the thinking about these issues, that can make those conversations have utility. And the ability to think about really complex issues that are extrinsic to the day-to-day business of resolving cases is compromised when you're just so pressed all the time to do the daily work in the somewhat reductive way that I'm, describing it as historically being done. So it's kind of a little cluster of problems, and so I just offer those thoughts for the group. I hope they're valuable to people, and we definitely have to find a way back to supporting, new thinking and reform efforts, because it has to change. What we're doing is not working very effectively for a lot of people, but the people in the system have to be able to help push for that change.
Thank you, Mr. Reed. Liz, if you have anything else to respond or not, I know Kenitra Brown might have a question.
Not so much a question as a thought. It kind of follows on what Thomas Reed was saying and the portion of your presentation about staffing personnel across systems, and what that means for backlogs, recruitment, retention, all of that. And it triggered a conversation with, surprisingly, a prosecutor and not a defense attorney about this problem of prosecutors being aware of the backlog and trying to reframe their discretion about what they really want to charge, about their charging practices, so that they can do their part to shrink this backlog or adjust thinking around reform. And that's difficult when you're talking to people who talk about indigent defense, about prosecutors actually saying, what is it, or what's the breadth of my discretion to dismiss charges, to not make the charge at all, to not do deferred, to not do diversion. But this was like parts that you did at the start of the pandemic. And I'm wondering if any follow-up has been with more prosecutors and kind of their perspective on this. We've got some who are saying, we're getting back to business as usual. And it's our job to enforce the law and make these charges. But then you've got another set who are realizing that in the systems that they're in, generally the lack of personnel and staffing is making it very, very hard to do business as usual. So they have to adjust how they think about their work too, and just kind of what you're seeing in your work or in the things that you're doing around it. I mean, you're seeing around these responses with prosecutors, because we tend to think more about defendants and defendant research and defendants themselves.
Yeah, yeah, I definitely see how that relates to what, Tom Reed was saying, which is that it's, there is this big picture reckoning with maybe we could do something to help mass incarceration. Maybe the pandemic is going to teach us that we don't have to, fight for bond in all these cases, or we don't have to charge all these types of cases. We can let people be out in the community. We did hear some people referencing like COVID discount, that was, we definitely heard that from defense, some defense attorneys. Some people said no, some people, I think maybe depending on the kind of cases that they were handling. I think whether or not that kind of framework, that kind of way of thinking is going to be sustained is a great area for research. And I don't have the answer. I think that probably some of the prosecutors we talked to will go back to business as usual, and some of them maybe not.
Well, thank you, folks. Benjamin has arrived, which must mean it's the end of the hour. I do want to make sure we're respecting everybody's time, but thank you so much, Professor Webster, for this presentation, and for everybody else for your attention. This has been a great session, very important issues, and really interesting and path-breaking work, which I appreciate that you shared. And thank you, everybody, for being here. We will see you again next time.
Thank you so much. Bye-bye.